Going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives Bagol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Hope. Here. Breen. Scott. Here. Madam Chair, you have 10 members present. You do have a quorum.
Thank you, Madam Clerk. Representative Schutte moves to excuse absent members. Hearing no objection, absent members are excused. We're going to have Representative Johnson do a motion to adopt the minutes from June 4th. Hearing no objection, the minutes are adopted. All right, we'll call the meeting back to order. We have a couple of votes today before us, or a few votes. First, we're going to start with House Bill 4396, which is the data sharing bill to allow for data sharing. It was my bill. We heard testimony on it the other day. And with that, we're going to have Rep. Bagol move House. Oh, let me read this card in first. This is a card of support for House Bill 4396 from the State Bar of Michigan from Nathan Triplett and does not wish to speak. So we'll go back to the motion. Rep. Bagol moves House Bill 4396 with recommendation. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson. Yes. Schutte.
Yes.
Carter.
Yes.
Hope.
Yes.
Breen. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. House Bill 4396 is reported with recommendation.
Thank you, Madam Clerk. Next, we're going to move on to House Bill 4418. I have a couple of cards for 4418 and 4419, actually. Not wishing to speak in support of the bill, Michigan Guardianship Association. 4418 and 4419 is substituted. Does not wish to speak, supports the bill, Michigan Health and Hospital Association. That's it. Okay. So on this first bill, we have to adopt the sub. There were a couple of technical changes that had to be made. And then I'll speak to it after we move the sub. So with that, we are going to adopt. We're going to have Rep. Wozniak adopt the H2 substitute for 4418. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Pope.
Yes.
Green. Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you, Madam Clerk. With that, I know there's been some discussion late in regards to this substitute. However, not much has changed since last week when we had testimony and we had support for the bill as written. I know there's been a little bit of contention I just want to address between a couple of entities in regards to consent. Right now, we have talked to legal counsel about this at length and contend that the bills as written are sufficient and do address the consent issue in other parts of law. And with that, we are going to go ahead and continue to vote on these bills. So I will move House Bill 4418 with recommendation. As substituted. H2, sorry. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Pass.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Pass.
Shooty.
Yes.
Carter.
Yes.
Pope.
Yes.
Green.
Aye.
Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 2 pass. House Bill 4418 is reported with recommendation as substitute H2.
Thank you, Madam Clerk. Next, we have House Bill 4419 by Rep. Witwer. We will have Rep. Wozniak move House Bill 4419 with recommendation. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Pope.
Yes.
Green.
Aye.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. All right. Well, next up, we are going to get to some business. We are going to have Rep. Wozniak testify in support of his bill 4524 as filed. And while he's going up to the chair down there, I'm going to read a couple of these. We will have Emily Dagnastini, I don't know, on Zoom, wishing to speak, supports the bill. And Emily, I will call you as soon as Rep. Wozniak is done, just as an FYI. And then we have David Peterson, who wishes to speak, supports the bill from the real property law section of the State Bar. And then we have Brad Ward, supports the bill, does not wish to speak, of the Michigan Realtors. And then we have Community Association Institute, Michigan chapter, not wishing to speak and supports the bill. Yeah, and David's at the podium with Wozniak. All right, Representative Wozniak, go ahead.
Thank you, Madam Chair. Well, this bill's been around the block a couple times, so I believe we've got all the stakeholders together finally to where we can put it to the floor. And I've brought in David Pearson from the Real Property Law section of the State Bar. So, David, take it away.
Thank you very much, Representative Wozniak and Chair. I appreciate the opportunity. I should preface my remarks by saying the Real Property Law section is a voluntary association of 3,400 real property lawyers who are members of the State Bar. We don't speak for the State Bar, we only speak for this section. Where this came from, frankly, were the 2018 amendments to the Marketable Record Title Act, but I should back up and give you some background. The Marketable Record Title Act was created in 1945 to simplify title and title searches. And in basic terms, if you can show that you've had clear title to your property for at least 40 years, you don't have to search any farther back. The issue before was you had to go back, frankly, to statehood or even further back in order to establish your title to a property. This meant that if you looked in those 40 years of records, if there was anything that affected your title, you would find it there and you didn't have to go farther. The difficulty that was created, as often happens, is how it's applied in practice. And there became a growing custom of putting in all real property instruments the proviso subject to, with variations, all easements and restrictions of record. And so the question became, did that then bring forward older restrictions which were beyond the 40 years, which meant that you'd sort of defeated the purpose of the whole thing. So the title industry that does the searches got tired, and finally in 2018, the legislature amended it to say that you could only affect that by including a proviso which specifically cited the Library page, the recording reference, for what it was that you were bringing forward. And it allowed a 2-year grace period for filing notices of claim to preserve any old interests. The difficulty is that under the Act, there were many old interests which everybody thought were still good, which in fact, by this treatment, had expired. The real issue was you have thousands of subdivisions created after the Second World War which really use restrictions in homeowners associations and depend on them. They own common property, they maintain it, as well as enforcing restrictions, and all of those would have fallen away under the amendment. What we did was put together a committee which came up with a reform package, heard from many other stakeholders who said there are other interests you should consider. Where this bill comes out is it says that effectively restrictions that were recorded up to 75 years ago now, so since January 1st of 1950, are exempt. You don't have to file a notice of claim, they're still good. That preserves those older subdivisions. The other interest is in the 50s, 60s, 70s, and 80s, you had the development of commercial malls and shopping centers with multiple owners who had agreements and easements where they shared parking, drainage, and other things. They're included too. This doesn't distinguish between residential and commercial property. In 2020, Eagle and the utility companies from around the state realized they were in trouble with their easements. The Act has already been amended to bring those easements back. All that this bill does is clarify some of that language to make clear that, in effect, if you have an easement that's old, you still have an easement. So those are well covered. That's really what the bill does. We're hoping, in effect, to put things back as a practical matter the way, frankly, the real property bar understood the Act to operate before the amendments. And the original proponents of the amendments agree that this is a fair and reasonable resolution. I'd be glad to answer any questions you have.
I believe I may have someone on Zoom.
Yep, we will go ahead and go to Emily. Emily, are you there?
Can you hear me okay?
Yep, all set.
All right, great. Ladies and gentlemen, thank you for the opportunity to testify before you today. Couldn't agree with Mr. Pearson more in his very detailed explanation of this difficult to tackle subject. I can't add a better explanation of it. What I will add, however, as briefly as possible, is the impression upon you that this legislation that the bill 4824, I think it is attempting to, we'll say fix, 4524 is attempting to fix, was passed in December of 2018. So from January of 2019, literally until today, we have been amending that legislation to delay the effective date because all of the stakeholders involved realized that in December of 2018, the law that was passed was not good law. It wasn't good for the attorneys. It wasn't good for the title companies. It wasn't good for the real estate owning public because it somewhat threw out the baby with the bathwater in that a lot of very valuable restrictions would have gone away by making this law take effect. So in the last, call it 7 years, folks like the real property law section and David Pearson, folks like us with ICSC, and all of the member stakeholders, real property owners, shopping center, commercial building owners, the condominium association, the board of realtors. We've not only passed little fixes here and there along the way, you know, as Rep. Wozniak said, this thing has been around the block a few times. But we finally, after this amount of time, have gotten together to prepare legislation that accommodates everybody's best interests. And I think that is what we have before you today. It's been a long process, but except for maybe one minor modification that is coming in the next 5 days or so, we are there, and we're very glad that we're in a position to maybe put this behind us. I also welcome questions. I can get into the weeds on the details and the legal positions. So whatever you may have, I'm available.
It doesn't look like we have any questions today.
One more comment.
Sure.
Could I make one addition that Emily's remarks reminded me, which I want to make sure you're aware of? As she said, the legislature has been extending the effect of this by 2-year increments since 2019. That runs out in September of this year. So our hope is that rather than asking you to do another extension, that we have the bill that is agreed upon and that this will move and obviate the need and can happen by September. We appreciate that.
Oh, we do have a question. Rep. DeBoyer.
So this is a very convoluted, complicated thing when you dig into it. The 40-year provision will still exist for certain things,
Oh, yes, for title.
for title.
For ownership of property.
but claims could go back to legitimate claims that had been filed, or deed restrictions,
Correct.
or easements.
Correct. So, and if you have claims that would have been cut off as of the effective date of the 2018 legislation, those are essentially held in abeyance until this passes.
Right.
And then there's a 2-year grace period to settle those.
Okay. Okay. All right. Thank you.
Yeah, so the important thing that David's talking about is the sunset that's coming up in September. Thank you.
Thank you, Representative, and thank you for being here as well. If we have any other questions, we'll bring those up because it's my understanding there's a little work to be done, and we're going to have a sub in 2 weeks when we meet again. Thank you. We're going to go at ease.
Okay, Judiciary Committee will come back to order. Okay, now we're going to take some testimony from Representative Lightner on her bill 4506 and 45 through 08, resentencing process for murderers who commit the crime at ages 19 to 20. Representative?
Thank you, Chair and members of the committee. Today I come before you, I got to tell a little story first. So we all are aware that we had to resentence numerous juveniles when we did the raise the age legislation a few years ago. We have been going through that process. And in April, it just got extended to 19 and 20-year-olds as well, so young adults. And what I want people to realize is these cases are the worst of the worst of juveniles and young adults that have committed murder, numerous murders, and that are being resentenced. And I attended one of these resentencing hearings in November of last year here in Ingham County. And it's actually my friend's grandmother and her caretaker were murdered in the late 70s. And the gentleman that committed that murder was 18 years old. It was like the day after his birthday. So he got a resentencing hearing. And this case was ridiculous in my mind. These ladies were beat to death in their home by a piece of furniture in their own home. So badly, they were unrecognizable. And there were two of them. So they were both beat to death. And then all he did is take their car and go back home. It was a neighbor. So when we had the resentencing hearing, due to, restrictions in the law, we could not have life without parole. And at his resentencing hearing, it was determined that the current sentence of 40 to 60 years was going to stick. That was on a Monday. Wednesday morning, I got a text from the family saying he's been fully released from prison. And I texted Kyle, I think who is in this room, Kaminsky from Department of Corrections, and I'm like, what? Is this true? What the heck? So prior to 1998, we also had what I'm going to call good time. I can't remember the technical term, but I'm going to say it's good time. So what happened was he was basically deemed time served because even though he got 40 to 60 years times 2, it was concurrent sentencing, which means they just run at the same time. So it took the decision out of the parole board's hands, no review, just that resentencing hearing, and this gentleman was let out. And because also he was deemed time served, we cannot spend money on him. So that will lead into another conversation very shortly. But because of that, I took great issue with that because this family still lives in the area, and we don't know where this guy's at. And quite frankly, he should have never been let out of prison. And so what my bill does, or bills, there's numerous. One, it allows prosecutors for more time. So time is of the essence in this bill. Allows prosecutors more time to review those life without parole cases, to ask that life without parole still be applied when they do the resentencing hearings. It also makes it so sentences for the 19 and 20-year-olds will run consecutive. If they get resentenced, we can't give them life without parole, but it will change their sentencing to consecutive instead of concurrent, because there's no reason someone that has multiple murders should be allowed to walk out of prison. The families that they affected don't get second chances, and I'm sorry, but when there's multiples, I think that's even worse. So they can go through the parole process and the eligibility then, but their sentences should run consecutively instead of concurrently. And then the last thing is, it talks about that in the analysis. So one bill is technical for the health code, public health code, and one is for the penal code, and then there's the sentencing and the prosecutor issue. So that's what the three bills are, and that's what they do. And again, I can't emphasize enough that this is for the worst of the worst. It's very few crimes. You'll see it's first-degree murders, murders of a police officer, murders including drugging, fentanyl, the ones that we made changes for a couple of years ago. That's it. So it's not like it's just like an assault crime or something like that. These are the worst of the worst. And this is what it applies to. And this helps continue to make sure we have safe cities, safe communities, and that people seek justice in our system, have faith in our system, because we also have truth in sentencing. So you really should do, life or a set term of years, but consecutively if you have multiple murders.
Okay, thanks for your testimony. That's amazing that was done. So in full support. Okay, not seeing any questions, we will go at ease.
All right, we're going to go back to order. And we have the Kalamazoo County Prosecutor, Jeff Getting, on the phone, or on Zoom right now, wishing to speak, supporting the bill. Jeff, you have the floor. Thank you, and thank you for being here today.
Thank you very much. Good morning, Madam Chair, members of the committee. As you know, my name is Jeff Getting. I'm the Kalamazoo County Prosecuting Attorney. I'm a member of the Prosecuting Attorneys Association Board of Directors and the immediate past president. Thank you for the opportunity to speak with regard to House Bills 4506, 07, 08. I am speaking not only on my behalf and as prosecutor of Kalamazoo County, but also on behalf of the Prosecuting Attorneys Association of Michigan. The officers have had the opportunity to meet and vote in support of these bills. I briefly would like to highlight a couple of things that these bills do. You've heard testimony already regarding the impact that these court decisions have had on victims throughout the state of Michigan. Hundreds of cases are impacted by the last court decision, and this bill 4506 and its companions, I think, help to maybe put forward victims in these cases in an appropriate way. These bills importantly continue to allow for life without parole as an option in these cases. There are instances, frankly, where I believe that that is the only appropriate sanction. Look to the Oxford High School shooting in Oakland County, and there is no choice, I think, in situations like that other than a sentence of life without parole, and this package of bills continues that as an option. Importantly, it provides realistic timeframes for making decisions on when to request a life without parole sentence, both for new cases going forward and for those past convictions where there is retroactive application. As has happened to the chair, these are cases that will go back into the 1980s, 1970s, and require rehearings on cases that are, not just 5 years old, but 10, 20, 30 years old, where we're going to have to contact the victims, review prison records, and make important decisions about when to seek life without parole and when a term of years is a more realistic option in these cases. It also importantly, I think, prioritizes the orders for hearings on these cases. There are over 600 cases that are going to have hearings here in the state of Michigan. This sets forth a plan in order to address those cases in a timely fashion, and importantly, to do those cases in an order where of importance that makes sense. Specifically, this statute allows for the court to take into consideration the circumstances of the offense in making its decisions and focus not just on the defendant and the rehabilitative factors that are set out in Miller versus Alabama and subsequent Michigan appellate case law, but also to look at what happened. And as you have heard, some of these cases are the worst of the worst. Home invasions where multiple people were killed, sexual assaults having taken place and then leading to the death of persons, individuals who have been dismembered and had pieces of well, had their heads carried around with them by defendants. These facts of the case are important things in determining an appropriate consequence, as was, the instance in Oxford recently. One of the things that I like best about this bill, frankly, is it centers victims and it addresses victims' rights. When you look at the Michigan Supreme Court's last decision, I don't think that they used the word victim. I will bet right now they didn't use the word victim 5 times in their entirety of their opinion. This addresses victims' rights and it requires that victims be allowed to make an impact statement at any resentencing hearing. It sets out a proportional sentencing structure for cases where life without parole is not going to be the sentence that's imposed, requiring a maximum sentence of not less than 80 years, minimum sentences that have to fall between 35 and 50 years. If we're not going to use life without parole, we do need to keep in mind the severity of the offense and make sure that the sanctions that are imposed for any term of years recognizes and are proportional to the offense. Murder. There is nothing that we do as prosecutors that has a greater impact in our community or on our victims. And a 35 to 50 year minimum and maximums that start at 80, I think takes that into account in a way that we all can support. And lastly, consecutive sentencing is important, as already has been testified to. When you have multiple murders, concurrent sentencing fails to take into account one of the victims. When you have other offenses that have occurred, like home invasion, like sexual assault, like carjacking, like armed robbery, when we focus solely on one sentence for one crime, we're ignoring all of the other victims. We're ignoring all of the other crimes that took place. And House Bills 4506 through 08 helps to address that in a way that supports victims, supports community safety, and is, I think, an appropriate response to the situation we find ourselves in now. While I disagree with the Michigan Supreme Court's opinions, I understand the reasons behind them, and I think that this legislative response to the most recent decision by the Michigan Supreme Court is an appropriate one that does center victims and provide for public safety. I'd be happy to answer any questions that you have. Thank you.
Thank you, Prosecutor. We do have one question right now. Rep. Hope.
Thank you, Madam Chair. Some of these are comments and some are questions, if you'll give me a little bit of leeway. First of all, I guess I want to know how these consecutive sentences, which as a practical matter could be up to 85 years, I believe, don't run afoul of the Constitution. That's a question I have. And then I guess, well, the reason I say that is because factually it ends up being life, and not too many people are going to live longer than 85 years once they've gotten to prison. But a couple other comments I wanted to make. Reference to the Oxford shooting, that was obviously horrific and terrible, but that defendant had a Miller hearing, so it's not really applicable here. And then I guess I'll save my other comment maybe for another time or an offline discussion, but that's what I have to say about this right now.
And Jeff, you can weigh in on this as well, but it's 80 years is the max right now. But the thing is, consecutive sentencing, like the prosecutor alluded to, actually takes into account the numerous victims. When you do concurrent sentencing, like in the case that we had, he only did time for one murder, not two. And, this is just one case. And like I said, it's the worst of the worst. And life without parole can still be applied to some of these, with the time frame that's given, though. Some of the prosecutors might have some difficulty in that short time frame. getting everything together for the hearing, and asking for that again. And since the resentencing hearings have been happening, I think there were still, I had it earlier, there's still like 20 some people have been resentenced to life without parole, because sometimes it is proportionate to the crime. And that's what we have to remember here is we have victims that they have to go back to, or the victims' families, and say, hey, they got life without parole, but you know what? The Supreme Court decided to legislate from the bench, and now we have to resentence them. So we don't really have truth in sentencing when you have that happening. So that's why this legislation's needed. Jeff, if you want to add to that, feel free.
Yeah, a couple of things. It is important to note in the Oxford case that there was a Miller hearing, right? The United States Supreme Court required that for juveniles. Juvenile life without parole was not allowed to be a mandatory consequence. And in that case, that involved a juvenile, a person who was 15, 16 years old at the time of the offense. These are not those cases. These involve adults. These involve persons up to the age of 21. And so if we're going to require those kinds of protections for young adults, that's fine. But it's also important to remember that life without parole needs to be in a consequence that is available to the court for those instances where you have these horrific crimes involving multiple murders and other crimes that are committed during the commission of those crimes. With regard to the consecutive sentencing provision, as has been noted, when someone breaks into a home and kills 2, 3, 4 people, and they're sentenced to 35 to 80, 4 times. After they've served 35, they're eligible for the release. They may as well have only killed 1 person. The murder of the 2nd, 3rd, 4th person doesn't count. Under this bill, it allows for consecutive sentencing for those additional crimes. And it makes it again, as I said, we talk about centering the victims. I don't like having conversations with families and saying, well, yeah, it doesn't matter that both of your children were killed, that both of your parents were killed, that an entire family was killed. Those are the conversations I'm having. Nope, that victim doesn't count. This legislation means that victims count. And that's important, frankly. And these cases are incredibly hard, right? I did personally tell victims' families that when that conviction for life, first-degree murder was entered, when the jury found that defendant guilty, I told them that the judge doesn't have discretion. This is life without parole, period. And they left my office knowing that the defendant was going to be incarcerated for the rest of his life. And now I am calling them. I am sending them letters. I am sitting down in my office with them and telling them, I know you were told that by a judge. I know you were told that by a former prosecutor. I know you were told that by me. And having to say, nope, that's not true. Because as has been noted, out of the hundreds and hundreds of resentencing hearings that have taken place involving juveniles and then 18-year-olds and now 19 and 20-year-olds, the number of people that are actually receiving a sentence of life without the possibility of parole is a handful. People are getting terms of years, period. And the handful that get a life without parole sentence when they go up on appeal to the Court of Appeals or to the Michigan Supreme Court, most of those are being overturned. The number of people that are actually going to serve a life without parole sentence is minimal. Minimal. And I'm telling them, I'm having to tell them I'm sorry. I didn't have anything to do with it. That was the law. What I told you was true at the time, but now it's not. And the fact that more than 1 person was killed should matter. But under the law today, it doesn't. This legislation fixes that. And that is incredibly important. It is incredibly important for the victims. You know, when I read the last opinion by the Michigan Supreme Court, as I said, I'll bet you they didn't use the word victim 5 times. We have completely lost focus of what the criminal justice system, who the criminal justice system should be serving. I get it. I know that my job is to protect the rights of all of the people, including defendants. And I do that every single day to the best of my ability. But when we lose sight of victims and prioritize defendants, public safety, we lose. Communities lose. Our state is losing. Public safety is losing. And this bill helps to balance the scales in a way that I think is appropriate.
Thanks, Jeff. We have another question. Minority Vice Chair Carter.
Thank you, Madam Chair. Real quick, so I've spent probably more time than I needed to in courtrooms listening to plea deals. Usually when there's a plea deal, everything is put together and it's run consecutive. How many of these were actual trials that we're talking about, and how many were plea deals? Concurrent.
Every one of the case that's a retroactive case where the defendant was sentenced to life without the possibility of parole, I'm sure every one of those was trials. Defendants don't plead guilty and put themselves in prison for the remainder of their lives. Man, I've had one case in 35 years that was a plea to first-degree murder in my career. So those are all trials. The other sentences, you're right, 95%, maybe more than that, of the criminal cases that we prosecute end up in negotiated resolutions, plea agreements. Most of the time, sometimes those result in consecutive sentences, but the default in the state of Michigan is concurrent sentencing, not consecutive. You steal 5 cars, get prosecuted for 5 cases, you're going to get concurrent time. You're not getting consecutive time for offenses like that.
Thank you. We are going to have to move on. We have 4 more speakers right now, and the last 4 that I'm going to call up, if you could keep it to just under 5 minutes, I will be having to keep time because I do want everybody to be able to speak, at least for a couple of minutes. So next we are going to have Roberta Gartley come up. Supports the bill and wishes to speak. Thank you, Bobby. Red button. Yeah, there you go.
Good morning, members of committee. I am here today to express my opposition for the Michigan Supreme Court's ruling that prohibited sentencing individuals under the age of 21 to life without parole. If someone commits felony homicide, armed robbery, rape, or similar violent crimes, they should be punished to the fullest extent of the law, regardless of their age, which is life without parole. These are not minor mistakes or misjudgments. These are deliberate actions that inflict irreversible harm or death on others. By the time a child enters kindergarten, they understand the most basic rules of right and wrong. You cannot kill, you cannot hurt others, you cannot take what does not belong to you. Age should not be a shield for violent criminal behavior. We live in a society where juveniles as young as 11 can legally obtain health care without parental consent or notification. Yet we're told they're too immature to be held fully accountable for violent crimes. If we give them that level of autonomy, they should also be made to bear the consequences of their actions. In other words, serve life without parole. If you commit an adult crime, you serve adult time. Some argue that juveniles can be rehabilitated, but the truth is not everyone can. You cannot teach someone a conscience. Violent offenders, regardless of age, frequently repeat their crimes, putting innocent lives in danger once again. Releasing them back into society doesn't protect the public. It creates more victims. Let me be clear. I am not speaking from a distance. I am not just a concerned citizen. I am a grieving mother. My son was murdered on June 5th, 2023 in Detroit, Michigan. The young men who killed him were 18, 19, 20, and 22 years of age. They all took plea deals. 3 of them are trying to get appeals. Because of this ruling, they could now be eligible for resentencing and early release if they are granted appeals. How is this justice for my son, my family, or the hundreds of people whose lives he touched? At a 2024 Crime Victims Advocacy event hosted by the Macomb County Prosecutor's Office, I met a woman whose life was forever changed by a carjacking and murder that happened in the late 1980s. All the perpetrators were minors at the time and originally sentenced to life without parole. They were all granted Miller hearings. All the court records were lost, but thankfully her mother and grandmother had kept good records. In the end, they were all released. She now lives in fear as she had to testify against them. They have her address, they have her phone number, etc. She has been re-victimized by a system that has forgotten her trauma. This is what we're creating by reopening these cases. We're protecting the violent offenders and abandoning the survivors. The argument that life without parole is cruel and unusual for juveniles ignores the cruel and unusual nature of their crimes. What about the pain, fear, and permanent loss the victims experience? What about the victims' families who live with the consequences every single day? Why isn't this considered cruel and unusual? Adults 21 and older are held accountable for their actions, even though we also struggle with poor impulse control, poor judgment, and peer pressure. Poor impulse control doesn't magically go away with age. Peer pressure doesn't go away with age either. How many times have you been out with friends and say, I'm only gonna have 1 drink and not stay out late? Then the next thing you know, you've had a few and it's several hours have gone by. We've all been there. This is just a small example of poor impulse control and peer pressure. We all know how easy it is to make a bad decision in a moment. But when that bad decision is the taking of a life, there must be consequences. Serious crimes deserve serious penalties, no matter what the age of the perpetrator. And if that crime falls under the statute of life without parole, then by all means, they should serve it regardless of age. In closing, I ask this committee, who are we protecting by this ruling? Not society, not victims, not the voting, tax-paying public and their families. We are putting murderers and violent offenders back on the street, where they are free to hurt others again, only this time with the knowledge of how to get away with it. That is not justice, that's negligence. Thank you for your time and for listening to the voice of someone who has lived through the worst outcome of a system that prioritizes the rights of offenders over the safety of the public.
Thank you for coming to Lansing today, Bobby. And, we're sorry that you had to go through what you've had to go through and experience and losing your son and the justice system. And hopefully we can do better. Thank you. Next, we are going to have Maya Menlo of Criminal Defense Attorneys of Michigan wishing to speak and opposing the bill. If you could just couple minutes, that would be great. We have a couple more to get through. Thank you.
I'll do my best. Good morning, Madam Chair and members of the committee. My name is Maya Menlo. I have the pleasure of representing SATO and CDAM today and commenting on House Bills 4506, 4507, and 4508. Like the members of this committee, I have a special interest in the judicial system and criminal justice. I attended the Ford School of Public Policy, then went on to graduate from Yale Law School with my JD. I came back to Michigan and served as a public defender at the Washtenaw County Office of the Public Defender and then transitioned to appeals. I've been with SATO, the State Appellate Defender Office, since 2019. At SATO, I have had the privilege of representing clients all over our state and also of developing a robust practice in the Michigan Supreme Court. As this committee knows, there are a variety of cases, both from the United States Supreme Court and the Michigan Supreme Court, that address youth sentencing. The committee is likely familiar with cases like Roper, Miller, and Montgomery from the United States Supreme Court, Parks and Poole from the Michigan Supreme Court, recently Zarnicki and Taylor, and then there are, of course, other states that have gone in similar directions. All of these cases involve homicides. All of these cases are horrible, they are regrettable, they are unacceptable offenses that never should have happened. And the courts and the existing statutory schemes recognize the severity of the offenses. There is no question that these offenses require a serious response from the legal system. At the same time, the Constitution, both of the United States, the Michigan Constitution, and the case law interpreting those constitutions require that courts engage in an individualized sentencing proceeding where youth is considered at that sentencing hearing. And that's because youth are different. The brain science recognizes that, and the case law has followed suit. There are different accountability measures that are appropriate because youth have different capabilities when it comes to rehabilitation and growth. For that reason, for all but the rare youth, the Constitution requires a meaningful opportunity for release. But House Bill 4506 sets a bare minimum of 35 years, all the way up to 50 years on the minimum. These sentences fail to allow a meaningful opportunity at release based on demonstrated maturity and rehabilitation. The United States Sentencing Commission defines a life sentence as a period of incarceration longer than 39 years, and most of the sentences authorized by 4506 would exceed that life sentence definition. We know that life is disproportionate and unconstitutional for all but the rarest of youth, and therefore, this brings us to the first constitutional problem with 4506. It is cruel or unusual, and it would be disproportionate to sentence youth who have not been determined to be candidates for life without parole to a life sentence, a de facto life sentence, that is. Beyond that, 4506 has a number of other constitutional infirmities that would lead to prolonged and likely successful litigation, and I'd like to touch on some of those briefly. They are equal protection violations, separation of powers violations, and ex post facto violations. So first, the equal protection violation arises because the Michigan Supreme Court in Zarnecki and Taylor has said that 19 and 20-year-olds are indistinguishable from 18-year-olds for the purposes of sentencing. And yet, 4506 treats these two classes, 18-year-olds and then 19 and 20-year-olds on the other hand, as distinct. That's unsupported by science, and it is the opposite of what the Michigan Supreme Court held in Zarnecki and Taylor. So given the brain science and the court's conclusions about it, treating 19 and 20-year-olds differently from 18-year-olds would be disparate and would violate equal protection. Moving on to separation of powers. There are issues with separation of powers both as to the judiciary and the executive. So again, in its opinion in Zarnecki and Taylor, the Michigan Supreme Court held, and I quote, accordingly, individuals convicted of first-degree murder for conduct occurring when they are 19 or 20 years old must receive the same individualized sentencing procedure under MCL 769.25 and are related decisions as juveniles who have committed first-degree murder. So therefore, 4506 conflicts directly with the language of the Michigan Supreme Court's opinion. It's a clear separation of powers violation. There's also an issue as to the executive branch, and that is because in Michigan we, of course, have indeterminate sentencing, which imbues the parole board with the authority to review an individual when they have served their minimum term. Here, however, we have a bill that would provide for a de facto life sentence, like 35 years, 40, 45, or 50 years, not to mention the consecutive sentencing provisions, and that would not give the parole board the meaningful jurisdiction over a person that they are required to have under Michigan's Constitution. I'd also like to address the ex post facto issue, which I think was alluded to earlier. An ex post facto violation occurs when the legislature increases a punishment after the date of the offense. So for 4506, it seeks to impose mandatory consecutive sentencing on everyone who has ever been convicted of a murder and of any related crimes that arising out of the same transaction. And that's an issue because it would be applied to people whose offenses occurred before the effective date of the bill. And there we have an ex post facto problem. It also runs afoul of Michigan's strong presumption of concurrent sentencing, but that's sort of separate and more of a case law issue, whereas the ex post facto violation is something that we could expect to run into problems with in the courts. I'll close by mentioning just that litigation will, of course, create delay. Delay in resentencings is not good for victims. It's not good for people who SATO and CDAM represent, and it's not good for courts or the public. Delay will result in keeping older, rehabilitated people in prison who do not need to be there. Generally, elderly people are, of course, the most expensive people to incarcerate, and so that is a cost that will be coming out of our taxpayers' pockets. Term of year sentences pursuant to MCL 76925 are constitutional. The courts have upheld them, and they provide victims, the courts, and the public with finality. We know that MCL 76925 works because we can look to the low recidivism rates among juvenile lifers, both locally and nationwide. With that, I will thank the committee for its time, and I'm happy to answer any questions.
We do not have any questions. Oh, do you have a question, Jet? Okay. Well, we're going to have further discussions, I'm sure, but thank you for your testimony and your points. Next, we're going to have Joshua Puckett from Adolescent Redemptive and Restorative Programs, wishing to speak and opposes the bill.
Am I hot? Yep. Okay, yes. My name is Josh Puckett. I'm from the Adolescent Redemptive and Restorative Programs. My programs are used across the state of Michigan within the Department of Corrections to create rehabilitation attached to the National Lifers of America Association. So my programs are going directly gang intervention, gun violence intervention. We do power of the grind, mentorship, goal setting. We also do civic engagement training courses. And the reason that I'm here to speak today is because I am and was one of those people you're talking about. I was the worst of the worst. I was a gang member. I did 30 years as an 18-year-old. I was released last year, July 17th. I needed to be in prison. I needed to be rehabilitated. I needed to serve my time. I can say that I needed to serve a minimum of 15 years just to get to where my headspace could be rehabilitated. And then I needed to serve further time so that I could become the person that could be safe to release to society. I got educated. I got 3 degrees. I went through multiple programs. I worked on my traumas. And in my case, in Wayne County, my victims said that they did not oppose me. That allowed my judge to utilize his discretion. I was supported by my judge in the end and by the prosecutor's office, who said that I am an example of Miller versus Alabama. I'm an example of rehabilitation. This bill would take away those judges' discretion to utilize their power. We elect them to use their discretion. We elect them to be able to look at cases like mine. I'm sure there are other cases that are bad, but I can tell you for sure, mine was a gang-related drive-by shooting that killed a 12-year-old child. It was horrible. But I'm also a victim of violent crime. My mother and her wife were killed in a hate crime. The Affirmations LGBTQ Community Center on 9 Mile is named after them. I know the pain of losing a loved one, and I did that same thing to another family. There are many men and women inside prison that strive, just like me, to be a better human being, to come back out and atone, to write programs and do things in their communities to make it better, to make up for the pain and the loss that they caused. Those individuals will be reviewed by the judge and will be reviewed by the prosecutor. These are people that are elected by the people to do these jobs. And this bill takes away their ability to utilize that discretion. We need to allow our elected officials in those positions who know these cases, who have dealt with them, to use the discretion that they've been afforded by the taxpayers and the voters in their districts. Thank you.
Thank you. Next, we have Monica Janer. Okay. If you could just be a couple of minutes, that would be great. Arrow. Yep. Wishing to speak and opposing the bill.
I gave written testimony, but at the time I did not know Rep. Lightner was going to come up here and get personal to a situation that I did the reentry. And what was not spoken about the young man was that he was guilty but mentally ill. He went to prison for 49 years, which if you put 25 and 25 is both victims. He's got 49 years in. This man has mental issues. I got his records from the Department of Corrections, and they did not give him anti-mental treatment while he was there. He cannot read or write because he was a lifer, so they didn't give him any education. So we've left out the part also that he had a very bad childhood, and there was an article in the paper when he got arrested about how bad his life had been. None of his family can read or write. He was in poverty. He had ran away. He left home because he was being abused. So I'm not making excuses for the man at all, but I got him a therapist on the first day when he walked out the door. I got him housing. I got him a place to stay. He's got an ID. He's got food. He's got a group of people that are taking care of him that is amazing. And it wasn't because the Department of Corrections put in any money, because they don't do anything for discharge. So I hope on the next bill you will rule that they give some funding for people that are discharged. But none of the real facts of this man had been stated. And he should not have
Well,
gone.
that's post-release, ma'am. I will argue with you day and night because I know these people as well. So the facts were there. He committed murder times
No
two
doubt.
of two elderly women when he was 18. It's not, at that point, he should have been able to read and write. I don't know why the education system failed him at that point. So,
What about the mental
ma'am,
health
we are going to
system?
move on. I am going to move on from you. Thank
Okay,
you.
yeah, I was no disrespect to you. I just want.
Thank you, ma'am. We are going to move on.
Okay.
Okay, so next we have, not wishing to speak, Gabrielle Dresner from ACLU of Michigan, opposing the bill. Tony Gant of, I don't know, Michigan Collaborative to End Mass Incarceration, opposing the bill, does not wish to speak. Hakeem Crampton, Citizens for Prison Reform, opposing the bill, does not wish to speak. John Cooper of Safe and Just Michigan, opposing the bill, does not wish to speak. Jose Burgess, I can't read it. Life After 27, opposing the bill, does not wish to speak. And Eden Kinlock of FAM, opposing the bill, does not wish to speak. Jessica Perez, opposing the bill, does not wish to speak. Isaac Perez, opposing the bill, does not wish to speak. Jose Geralt, opposing the bills, does not wish to speak. Jeanette Geralt, opposing the bill, does not wish to speak. Jennifer, Cisne, opposing the bill, does not wish to speak. Michigan League for Public Policy, opposing the bills, does not wish to speak. Okay. All right. I think we are going to move on from this issue real quick. We're going to try to get in. Is Amos O'Neill's staff here? Okay. If you want to come up, we will address House Bill 4211.
Thank you, Madam Chair. My name is Mary Frank, and I'm Representative Amos O'Neill's Legislative Director. He is in another committee, and wants me to apologize for missing the committee meeting this morning. I'd like to briefly talk about his House Bill 4211 that will allow the Michigan Department of Corrections to give reentry services to a select group of individuals that are to be resentenced and released because of the cases with the Supreme and Michigan Court, the U.S. and Michigan Supreme Court cases for cases of mandatory life without parole. Thank you.
We have multiple people that want to speak. We have Kyle Kaminsky wishing to speak on this bill, supportive of the bill from Michigan Department of Corrections.
Thank you, and with permission, just to keep things moving along, if I can be joined by Angie Sprink from West Central Michigan Works. She's one of our
Sure.
reentry contractors. So,
Yes, Angie also has a card wishing to speak in support of the bill.
just
Thank you.
building on what Mary from Rep. O'Neill's office shared, the department is supportive of this bill because it answers a key question, which is after resentencing, what is our approach going to be as a state in some of these cases? The majority of these cases will still be under the jurisdiction of the MDOC, even if they receive a term of year sentence, meaning that they'll come back to prison. The parole board will consider them either immediately or some point in the future when they've served their minimum term, and they'll go through the normal parole process and have reentry supports through parole. There is a group of cases, though, as mentioned by the chair, where when they come back to prison and we receive that amended judgment of sentence, they are subject to immediate discharge from the Department of Corrections. There is no discretion on the part of the department as to whether that or not that person should be incarcerated any longer. We need to process them out of our facility essentially as fast as we can, and they return to the community. And so the question ultimately becomes, what's in the best interest of that community? Right now, the department cannot expend resources on those cases, meaning those people leave prison after a long period of time, decades in these, to be clear, with no direct support from the state. Now, there are providers around the state that work with these folks on a voluntary basis, and we're very appreciative of that, but ultimately they don't work with every case. And as a state, I think it's in our best interest to make sure that state resources are going to ensure that these folks are supported, not just for them, but again, for the communities that they're returning to. I will wrap up, but two things I want to be very clear about. The department has all of the infrastructure in place to do this, so we're not trying to create anything here. All we're asking for is permission to use that infrastructure for this group of cases that are going to be subject to immediate discharge. And also importantly, the department is not seeking any additional funding. We will cover this from our existing reentry resources, but we want to make sure that we can extend them to these important cases. But this is not a precursor to any type of budget request. This is a straightforward, let us do this work with our partners because we think it's in the best interest of communities. And with that, I'll turn it over to one of those partners, who is Angie Sprink.
Thank you, Madam Chair and Judiciary Committee, for allowing me time to testify today in House Bill 4211. As Kyle stated, I'm Angie Sprank, and I'm the Region 4 OS Coordinator, so I have 13 counties over on the west side of the state. I think it's important to note my career has been dedicated to the service of criminal justice. I spent the first half in crime victim services, and then my second half in reentry. I believe those two paths coming together have given me an insightful and well-rounded view of reentry. House Bill 4211 would expand services that would now impact the juvenile lifers that are left to be resentenced and the 19 and 20-year-olds. As Kyle mentioned, this is for services for those who would not be on parole. Those two populations are very unique given their age at the time they were incarcerated, but also the length of sentence that they served. Many do not have a support system to return to, leaving them homeless and navigating a society that they've been removed of for often decades. This not only negatively impacts the individual, but it negatively impacts the community that they are returning to. It can create an unsafe environment that can put additional strain on those living in the community, emergency services, local businesses, the economy. I have firsthand knowledge of the complex barriers that come with this population. Over the past 5 years, Region 4 has worked closely with SATO in accepting juvenile lifers resentenced without a term of parole who did not have a support system. Through funding sources made available by Michigan Works West Central and a grant received through the Michigan Justice Fund, we're able to provide them with comprehensive wraparound services, including transitional housing, which has led to their long-term success. In the 10 that we assisted just in this capacity, 9 remain successful in the community they returned to, and 1 unfortunately passed away. Passing House Bill 4211 is the resolution that provides the individuals with services they need to transition back to their community successfully, and that results in a safer community. OS reentry programs across the state are already properly equipped to do this work with these individuals, and if we do not assist them, we're putting the burden on the community, the homeless shelters, law enforcement, local businesses. So that is why I'm here today, to testify in support of House Bill 4211, and I thank you for your time today. And I'm happy to answer any questions if you have any.
Doesn't look like we have any. We're going to go ahead and move on at this point, but thanks, Kyle, on the PROPE side of things. As you know, I've sat on a PROPEs for years and years, but I know that when we do reentry, we already provide, documentation, work with Secretary of State, vital records, all of that stuff, so I appreciate that work. Next, we have Priscilla Bordeo from Crime Survivors for Safety and Justice, supporting the bill and wishing to speak.
There we go. Thank you so much for having me. My name is Priscilla Bordeo. I am the manager of partnerships for Crime Survivors for Safety and Justice, and I'm also a victim of childhood sexual assault. What I want most is for what happened to me never to happen to anyone else. I also want what happened to the victims I work with to never happen again. House Bill 4211 is a short bill with a deep impact. This bill changes the statute to address the possibility that a person may be immediately discharged from custody after a resentencing and allows the department to provide vital documents, including a state issue ID, a birth certificate, reentry housing, and transitional housing to those persons subject to a resentencing. Why is this bill important? because safety is paramount to victims of violent crimes like me. We appreciate the MDOC, prisoners' families, and community reentry organizations that help prepare people leaving prison with the tools and support they need to succeed. Current law does not provide MDOC with the authority to help juvenile lifers transition from prison to the community, like it does for all other people leaving MDOC. This bill changes that. These individuals may have gone to prison at the age of 17 or younger, and today they are full-grown adults. Many of them don't know how to drive, pay rent, find a job, and may lack familiarity with many things you and I depend on every day, like having a cell phone. House Bill 4211 will allow the Department of Corrections to begin the transition process sooner and play a critical role in making the transition from prison to community safer by connecting the prisoner access support for housing, necessary medical care, and other supports. The type of support proposed in this bill is commonplace for everyone else leaving Michigan's prison. This kind of help could make the difference for someone leaving prison, even helping prevent an individual from losing hope and committing a crime. As a citizen, a voter, and a victim of violent crime, my only request of lawmakers is that you vote to give the department the tools it needs to these newly released individuals to have the opportunity for success. On behalf of crime victims in Michigan, I thank you for including our voices in this process and in this bill. I ask that you will stand with us in support of House Bill 4211. Thank you.
Thank you. I'm going to go ahead and just read in some cards. Hakeem Crampton from Citizens for Prison Reform, not wishing to speak and supporting the bill. David DeHanser, Department of State, does not wish to speak and is neutral on the bill. Gabriel Dresner, ACLU of Michigan, supports the bill, does not wish to speak. And Jen DeMud, Michigan Works, Berrien, Cass, Van Buren, supports the bill and does not wish to speak. With that, because time has gotten away from us a little bit, we are going to address House Bills 4481, 4482, and 4483 at our next committee meeting. Thank you for your patience and interest in all these topics today. They're very important for our communities, important to me personally, important to lots of people, I think, on this committee, and look forward to further conversations. With that, no further business before the committee. We will adjourn.